Hi, everyone. Thank you for joining today's webinar presentation, Patent Drafting Best Practices, Latest Trends and Real-World Realities. I'm Gail Martin, Associate Marketing Manager at LexisNexis IP, and I want to cover a couple of things before we get started. Please feel free to submit questions by using the questions feature, and you can download a copy of the slides from today's presentation through the panel. A link to the recording from today will also be sent to you. Now, I'd like to introduce today's presenters. Jean Quinn. Jean is the founder of IPWatchdog.com, a patent attorney, law professor, and leading commentator on patent law and innovation policy. Jean was recently named one of the world's leading IP strategists by IAM for the second consecutive year. Salvador Bezos. Salvador is a director in Stern Kessler's Electronics Practice Group. Sal provides services in the preparation and prosecution of patent applications before the United States Patent and Trademark Office. He develops enforceable patent portfolios capable of withstanding scrutiny in America Invents Act, proceedings at the Patent Trial and Appeal Board. And he helps inventors navigate tricky post-Alice statutory subject matter issues in the business method and software spaces. Sal is an adjunct professor at George Mason University's Antonin Scalia Law School, where he has taught a course on patent writing since 2012. Jennifer Bailey. Jennifer is a partner at Arise IP and specializes in post-grant review of patents and patent prosecution in the electrical, computer software, and electromechanical arts. Jennifer has significant experience conducting post-grant proceedings in the U.S. and Europe. She is lead counsel on the first inter partes review filed under the America Invents Act. Jennifer is the immediate past president of the Association of Intellectual Property Firms. She frequently speaks on intellectual property issues and is a source for a number of news articles regarding intellectual property. Thank you again, everyone, for attending today's presentation. And with that, I will turn it over to you, Jean.
Thanks, Gail, and thank you all for joining us here today for this conversation on patent drafting. And thank you to Jennifer and Sal for joining me. During our prep call on Friday for this, we talked. So I have no doubt that we're going to have a very interesting conversation, and we could probably talk all day about these issues. So I'm looking forward to our conversation. Now, this is the outline of what we hope to cover today. And we have plans to cover all of it, but I suspect we're going to get a lot of questions, and we'll take it wherever the webinar leads us. But we'll pause here, and I'm going to bring in Jen and Sal to give us their preliminary thoughts on, in 2018, where are we with respect to drafting? So we'll start with Jen, and then Sal, I'll ask you the same question. Before we start to go through the substantive slides that we've prepared, what do you want the listeners to have in mind? Jen.
I think one of the biggest things for me in drafting is Alice and is IPR proofing. And we're going to discuss both of these issues. And so what I mean with respect to Alice is it's changed how we draft software applications. In my years of practice, we've gone through several different iterations. And I think an important thing as a prosecutor is to understand that you have to change the way that you draft your patent application as the law changes and matures. And you can't stick with the way that you learned 5, 10, 15, even 20, 25 years ago. And so in 2018, we're seeing new changes in the law, new ways of doing things, and we have to be amenable to changing our internal practice and not being set in our ways. And then the second part of that is trying to IPR proof our patent applications and issue patents as much as possible. And what I mean by that is, what can we put into the specification? What can we put into the claims to try to keep them from being invalidated in post-grant reviews and IPRs? It's a tall task. As a patent owner, it's gotten a little bit easier, but it's still a tall task. But there are tricks and things that we can do. And I know Sal and I were just going back and forth during our prep call on it, so we'll probably have more on that later.
Yeah, we have a slide for that, and that was actually the part of the call that got the most animated and we were in violent agreement, I think, on all of that. So looking forward to that. So Sal, your preliminary thoughts before we really kick off the substance. What do you want people to know?
Yeah, I totally agree with everything that Jennifer just said. I think I would add, and it's kind of on the bottom of the slide here, is that practitioners are being asked to do a lot more with less, oftentimes. And it's not necessarily something that in-house counsel would want us to be in that position. I think many understand the challenges with Alice and IPR proofing patents on very limited budgets. But we want to make sure that everyone's on the same page. We understand where the value proposition is for the portfolio, and that we are meeting the challenges as best we can with the tools we have head on. And so I think definitely understanding the challenges is a key part of that, but certainly being able to present them to your clients in a way that will facilitate the right business discussions around this is an important part of this as well.
Yeah, and that's a part that I want to definitely get to, and it came up during one of our previous webinars a couple weeks ago, and we probably need to spend, I think, an entire webinar on that, but we're going to touch on that here today, hopefully. So let's just kick it off here and identifying the invention and improvement. And most folks here on the webinar are probably familiar with this, but always like to have a slide here and not assume familiarity. But increasingly over the last several years, what we see in the software space, and that's where my experience is. That's where a lot of Jennifer's experiences are, and Sal has a lot of familiarity with the software and electrical spaces. And since really software is about 60% of applications now in one way, shape, or form, this is a big deal, and this is why we have to talk about changing our ways, right, Jen? I mean, because over the last couple of years, things have changed rather dramatically.
They have. It used to be that we would almost want to obfuscate the invention because we didn't want that to be the invention, because then you were held to it. And I think that really has turned 180 degrees in that we want to be able to have somewhere in the spec that we can point to say, this is the invention, examiner, jury, whatever the case may be. And I was talking to the guys about this. I work with a bunch of patent litigators, and they're always looking for their theme in the trial. What is the theme to the jury? What is the creative aspect of this invention that makes it cool that this jury, hey, you should find infringement and no invalidity? And that same concept of a theme, as much as I've pushed away from it as a prosecutor, I'm starting to embrace it and putting it into my patent application. But I want to be clear that I don't mean a single concept invention. I hate it when we draft a patent application, it's really only a single feature invention, because if that feature is known, then you're just out of luck for patentability. But understanding what that problem is and what the solution to the problem is, which is kind of the European aspect of the problem solution approach. And I'm going to let Gene and Sal talk about this because I know they have a lot of interesting options on it too.
Yeah, and Sal, one of the things that we talked about on Friday is about telling this story, right? You know, I've been a fan, and I've actually pushed back against this obfuscating the invention for a long time, even when that was in vogue, because I would read these applications and you get to the end and it's like, well, what was the invention? I don't really even understand what the patent attorney thought was new. I've always wanted to tell a story. And I think you can do that in a positive way without comparing it against the prior art, which is where you get into trouble.
Right. I mean, to Jen's point, I think that a lot of folks were sort of taking to heart cases that kind of showed the specific language in a patent application was detrimental, and just taking that at face value and minimizing the amount of content they were putting in their application. And for a while that worked, but we can't really do that. And really the challenge here is going to be, how do we pick the right things to put into an application? And, on our call on Friday, we talked about a background section, for example. A lot of people will just do without a background section. There's obviously a lot of case law around prior art admissions and some of the detrimental effects of a background. But, and I'm not talking about, a whole diatribe that goes on for pages and pages as a background, but a 1 or 2 paragraph background section that sets the stage and really tells sort of the context and sets you up is going to make sense to so many different audiences, and it's going to make all the difference when you get into your detailed description and really start talking about the innovative concepts in there. Going back to the problem solution approach that Jennifer was talking about, we still teach that in our class. And if you're just talking about a solution without any context for what the problem is, a lot of that's just going to go sailing over people's heads. So yeah, I think we do need to very carefully, and this is why it's not an easy task anymore, put the context in that's going to be needed to survive these IPR challenges, to survive litigation.
Yeah, and I couldn't agree anymore. And because I do think that there's a role for the background to set the table, to explain things, and you can do it in a way that doesn't lay the trap for the future, as long as you give some thought to what it is that you're doing, because you don't want to get in a position, especially now, knowing post ENFISH, all of these cases are, what is the improvement? Does it improve something? Because if it doesn't improve something, you're out of luck. I even know that there were some practitioners that after ENFISH, and this was before Berkheimer gave some real hope, were going back and adding, filing continuations in part, and they were adding language to distinguish the invention and explain why it was unique in the application, and then that they were being successful doing that. And I don't know that going back and doing that is what I want to encourage. I think I would personally encourage doing it, in the first instance. Now, obviously, there's good ways to do it, and there's bad ways to do it. You don't want to say the only thing that's unique here, like Jen was saying, but you gotta, I think, explain the invention. And I just think we've got kind of jumped the shark, right? If we are filing patent applications and are afraid to use the word invention, then something is very seriously wrong, I think. But let's push to that next slide. And this is just more of the invention improvement stuff from McCrow that was also there, just for your reference. And this, we're not going to go through the KSR rationales and turn this into an obviousness lecture, but whenever we talk about the background, I think the elephant in the room is KSR, right, Jen?
It is. And with respect to 101, this has been the problem all along with Alice. Is it really a 103 analysis versus a 101 analysis? But it does kind of come down to KSR. And something I do with these KSR rationales, why I think they're important to understand, it's not really for the purposes of trying to defeat an obviousness rejection during prosecution. It's looking at them and understanding, do you have a good idea of what the invention is in view of these KSR rationales? Can you go through each of them as the patent practitioner drafting that patent application and be able to explain and point to in your spec why combining the prior art elements isn't being done according to known methods? I think it's a useful tool to almost use in reverse to establish that for both 101 purposes and then, of course, 103 purposes.
I agree, because I think what happened, I think, is once you see number 5, obvious to try, and that's the big one from KSR, right? Because that clearly changed the law. Obvious to try was never a rationale to reject. Once obvious to try can become a rationale, even though In re Cuban limited it, then using the inventor's own words against them from the patent application becomes a rejection on steroids. So you don't want to say anything that could in any way lead the examiner to believe that, well, what happened was the next logical step, because if it's the next logical step, then it was expected and there was nothing innovative. So you can do such a good job describing the context that you talk your way out of a patent. So if you do a really good job getting over 101, then you walk into a 103, and we can't have that. But I think that fear, Sal, really is what led to a number of these patents post 2007 being, I don't even know what the word is. I don't know that poorly written is the word, but I think it was
Thin.
well, thin, but I think crafted in a
yes.
way. Well, maybe there's two problems, right? There's the thin problem we talked about on when with respect to maybe people who were doing this who weren't software savvy, and then there's the people who were software savvy that were maybe trying to get too cute. What do you think, Sal?
Yeah, there's a little bit of each. I mean, I think really if you are describing an improvement that by way of just what's going on in an algorithmic form, but you're not really tying it back to a specific performance improvement, and you can convey that by way of example, then you're going to run afoul of either 101 or 103, right? There's some sort of link missing there, and it's not a difficult gap to bridge if you have that understanding of why somebody would actually perform these steps the way that you've chosen to perform them. By the way, I was getting some feedback that I had an echo. Hopefully it's a bit better now. I picked up the receiver. But one of the things that I tried to do, there's kind of a weird esoteric example, and I'm not recommending anybody do this specifically, but on a 101 case where there was a specific abstract idea that it was an economic financial method. We took the purported abstract idea and put it into the preamble of a Jepson claim. And then put the balance of that improvement, obviously, in the structure of a Jepson claim into the body. And we're still fighting that, but I mean, it's an interesting way to kind of think about these issues. Again, Jepson claims extremely limiting, but I'm never going to say don't do it. But it's a good way to it's a good thought exercise, I think, for a lot of these questions. If you can describe the improvement in view of what a Jepson claim preamble would look like, then you've got sort of what you need to focus on.
That's an interesting thing to think about, because that certainly is something I think that you probably conceptually have to do, and that's, I think, goes along, Jen, with what you were saying about you got to think about the KSR rationales before you start drafting. What's your story to get past KSR? But let's pause for a minute and think about that. I think the patent industry has too many bright line rules. Don't do this, don't do this, don't do this, don't do this, do this, do this, do this. And if you go merrily along following all those, I think a lot of times you can walk smack into the problem that you're trying to avoid. Jen, thoughts on?
Yeah, I'm sitting here nodding my head, 100% wholeheartedly agree, because, and I'll say this having practiced for quite a bit of years now, with wisdom and maturity and age comes all that experience that I can now kind of sit back and go, all right, let's just use my common sense. What's the best way to present this particular invention? Because it's such a fact-intensive analysis for each invention, each market, each industry, where the law is in that particular period of time. So if we do try to follow this set box of rules every single time, I think we're kind of giving up using our experience and our common sense to help push these applications along. Because at the end of the day, I preach this to people on my team, the best thing you have for you is that common sense, which is kind of ironic that common sense is one of the obviousness issues that we face.
Yeah.
But I 100% agree, we can't just always stick to our strictures that are in place at that particular time because someone told us that, and that's the way it's supposed to be.
Yeah. Now, what I will say is, not knowing exactly who is on the other end listening to this, if there's younger attorneys or patent agents or folks earlier on in your career, what I would say, and Sal, I want to get you to weigh in on this because I know you've been teaching law school classes. more recently than I have with respect to this. What I would suggest is you got to know these bright line rules, and you in the beginning of your career probably want to be following more often than not. And if you're less experienced, you want to have an extremely good reason to violate one of these rules, because they are there for a reason, right, Sal?
Right. Well, I mean, to use the example I just gave a moment ago, pretty much any textbook on the subject of claim drafting will probably just flat out tell you don't use a Jepson claim, and they'll tell you to do to avoid many other things. But when you have all of these tools available to you, understanding the reason why you're being told not to do something as a general matter allows you to identify the exceptions and allows you to think creatively about what exactly are your client's needs in a given situation. And oftentimes when we're presented with a whole new landscape of, when Alice was handed down, when KSR was handed down, and all of the cases after that really clarify the bounds of their application, it's important to know what's in your toolbox, even if it's, as a general matter, not going to be used.
Right. I think that's important. Is you have to have it in your toolbox, and maybe it will be appropriate at some point. But I really like your suggestion about write a Jepson claim. You don't have to file it, but write it so that you can conceptually know what it is that you're trying to accomplish here, and what it is that you know and understand to be in the prior art. Because one of the one of the problems I think in a lot of these software cases is equal weight is given to describe things that are clearly not going to lead to the invention being considered patentable. And you got to focus on what is new. But we've kind of probably beat that horse to death. So let's go. I mean, this is I think going to be an exciting slide here. This is the IPR proofing your patent. I mean, when this, Jen, has to be in your mind when you're writing these things, because if it's commercially valuable, you are going to be IPR'd.
You are. And IPR proofing is not easy to do. It takes time. Frankly, I don't really concentrate on IPR proofing my claims, especially until I'm far into continuation practice, which is usually when the market starts to develop enough that you can actually make claims that have that scope that addresses the market development. It just takes time. That's why it's usually in continuation. But what do we mean by IPR proofing? I think this phrase gets thrown around a lot nowadays, but Sal and I and Jean, we want to try to give you some actual things to do. And one of the things I do a lot is with my dependent claims. So you might keep your independent claim the way that you would always want it with that particular scope, but sometimes it's very common to have dependent claim 6 to depend from 5, depend from 4, depend from 3. And so if you think about it, when you go to set up the petitioner in an IPR goes to set up their ground of rejection, all they have to do is have their primary reference and secondary reference for independent claim 1, and then they just tack on additional references to follow your little cascading, waterfalling claim dependency. Instead, consider setting up your dependent claims into kind of 2, 3, 4 different groups within each claim set, so that it makes it harder for them to set up a ground of unpatentability for those multiple dependent claims. I'm not saying do multiple dependent claims, but for claims 3, 4, 5, for example. So I would do like 5 depends from 4, depends from 1, and then maybe a claim where it's 4 and 5 together, but now we're going to have claim 6, and 6 depends from this. So it sets up different permutations of claim scope, and I talk about this a lot because we should all be telling our clients this: there's no such thing as one independent claim that's going to cover every circumstance of infringement and be completely valid. So we need those different permutations of claim scope. So I'm going to pause there. Gene?
No, I mean, I think I'm all in favor of that. I think that that is an important consideration, because one of the things, I just was at LES last week and I was on a panel and we talked about how many patents or assets do you really need to have your portfolio sort of IPR proofed? And the concept was, how big does it have to be in order to get the defendant to want to really take a license versus finding it more economical to challenge everything you have? And of course, that number varies depending upon what it is you're seeking, who it is you're suing, and what industry, and et cetera. But sometimes that number is quite a bit lower than a lot of people think. It can be 10 or 15 good assets that are being infringed. Then when you do run the math, it becomes more economical to take a license than it is to fight them. So this is a great strategy. What you're trying to do is you're trying to make it less attractive for them to file an IPR, more expensive for them to file an IPR, more expensive to file the petition just for the fee itself, and more expensive for the lawyer's fees. And then you're adding a layer of uncertainty. So I think it's a great strategy. Sal, your thoughts?
Yeah, so I would add, I mean, just think about what a petition would have to look like if you had your standard 20 claim, 3 independent claim application to deal with, where every single one of those 20 claims is unique in its own way, and the petitioner wouldn't be able to kind of attack the 3 independent claims as a group, just addressing that they're separate statutory classes, or even address batches of dependent claims. So, as Jennifer mentioned, if you kind of switch to something closer to a hub and spoke type layout for your claims, that's going to make a difference. Thinking about ways in which you can subtly vary even the independent claims can make a difference as well. But also, I mean, you have so many opportunities to make those dependent claims count in prosecution. And if you've got a continuation pending, that you can really target your claims down the road, making sure that you've got a disclosure that will support not just kind of the broad concepts that you'd probably target initially, but that you can target the infringer down the road. I mean, what better way to IPR proof your patent than to get down to the embodiment level? If you know what that embodiment is going to look like, because you have a target, you're probably in pretty good shape. That's about as good as it's going to get.
Yeah, and that brings up. Go ahead, Jay.
Sorry. Oh, I was just going to piggyback off of what Sal said, because I really like his idea of using different independent claims with minor language tweak. A couple of points on that. Sometimes when I get far into continuation practice, I'll hand the spec over to a different attorney and say, don't look at any claims that are issued in this family. Just read the spec and go write your own set of claims, because inevitably they're going to use different words and write the claim a different way. And that has such value when you're trying to IPR proof. And then kind of a related note to that is, think about, and this is especially helpful in software, think about what you can add to the claim that's not going to be in a primary or secondary reference. What kind of limitation can you add that doesn't really narrow the claim, because any infringer is going to have it, or especially if we're talking about a larger system where we can pull different components in, because then they have to add another reference for their ground of unpatentability. And from the PTAB's perspective, when you start getting into 3 or 4 reference combinations for unpatentability, especially for an independent claim, the obviousness of that independent claim becomes a lot less. I mean, yes, the number of references is not indicative of non-obviousness, but come on, in reality, they really are. It becomes harder for the petitioner to make their ground of obviousness.
Yeah, and I would certainly agree with that. And what I was going to say was, I was going to point out that what Sal was talking about was really probably the last 2 points on this page here about the continuations. And one of the things, my bugaboo about this is, it is shocking to me how often there is not an open continuation on an asset that is even quite valuable. Now, I get that if you work for a large corporation, that's probably not your issue. But it is with startups. It certainly is with independent inventors. It always is. But it is with even well-funded startups. You know, they get a patent, they close the case, they close the family, and then it becomes valuable, and there's nothing there. And I hear this from litigators all the time, far too often, that it's a nice patent and all, but I wish the specification was open and we could write some more claims, because if we could write some more claims, this would be pretty good. But once you close the family, any claims you would ever be able to go back and get are going to have intervening rights anyway. So I, like Jen, you had suggested that if you're going to close it, you can't just let it get closed with an email to the client, right?
Yes. So often as prosecutors, we have so much on our desk that we send our reminder emails like we're supposed to. We don't hear back from the client. Deadlines pass. But hey, we've done what we're supposed to, right? We send our reminders. I will tell you, in my office, we don't practice that way, and especially on continuations. On continuations, when we're to the point where we're about to decide to close a family, I get my client on the line and I read them the Riot Act. No matter who they are, no matter their skill level, no matter if they're in-house patent counsel for 15 years, I want them on the phone going, yes, I understand the issues that will happen and what I'm about to do in closing the family. This is such a big decision in the prosecution process, and the client needs to be fully aware of the decision they're about to be making.
Yeah, and because you also, I've talked with, and if anybody has sat in on any presentations with the funders, the money people, the financiers in the industry, they are all looking for open files. That's what they want. They want open files because they know if there's open files, they can IPR proof the stuff that they're going to fund in litigation. Sure, the assets that are going to get litigated are going to get IPR'd, but then once they get IPR'd, they're going to see the art, they're going to see the best swing, then they're going to go into the continuation and get better claims. That's what the money people are looking for. That's what the attorneys are looking for. And if you have any hope of getting contingency representation in today's marketplace, you absolutely, I think, have to have open continuations. Otherwise, you're not going to get it. It's impossible. Now, Sal, before we leave,
I would add.
Oh, go ahead.
I would add to that. I think many times when you don't have a particular target in mind for the claims, you're kind of operating in a vacuum before there's been any sort of decision on, a direction to assert. Maybe there aren't really any special competitors in that space that you can look at. There's kind of this sense that, okay, well, we got these really broad claims allowed, and that should weigh into that decision to close off the family and not file a continuation. We can't really go any broader. We're happy with what we've got. We're done, right? But I mean, if you look at that second bullet of this slide, it's, what is the infringer going to have that you can tailor a narrower claim to? I mean, to IPR proof, you're going to need to get to some level of specificity that the art isn't going to teach. And if you can get to that level of specificity by knowing what that target is, and by making sure that when you draft your disclosure, you've got concrete examples that you can point to, you're going to have a lot of flexibility down the road that what look like broad claims initially, and then you might be happy with, really, that's got its own set of challenges.
Yeah, and that's a good segue to our next point. And the last point on here is file a robust technical disclosure, and that brings us to the next slide, which is best practices for a robust disclosure. And the first point is mine, and it's my bugaboo, and I say it all the time, and I don't know whether I'm getting through to people or not, because I hear all the time that there's this magic rule that evil words, dirty words, 4-letter word, invention. You can't say the present invention or the invention anywhere in your application. And that is simply not the law. That is simply wrong. It's not what the cases say. And if you follow that bright line rule, you can walk smack into the problem that the bright line rule is there to prevent. Because what it should be viewed as a warning that you should have a more robust disclosure and not only limit yourself to one articulation of an invention that has all the time certain components. Because when you look at the cases from the Federal Circuit, the invention has always been described with A, B, C, D, and E. Every time it's been called the invention, every time it's been described, it's got those 5 elements. Well, of course you don't have support for a claim that would cover 4 elements because you've never articulated it as having 4 elements. So it's an inartful disclosure. Now, what you can do is you can obviously wind up with that being your invention when you are using that and constantly calling an embodiment your invention without any other examples, because and that's the Honeywell case, right? That's one of the cases where it scared everybody to death. It's like the public is entitled to take the patentee at his or her word. Well, but don't miss the point that it was a defective disclosure. It was, or not maybe defective, but it was limiting. It was a limiting disclosure. And then the next point up here is about explaining functionality. Hopefully everybody understands this, but I run into this problem too. And Jen, this starts to get into some of your means plus function slides, which we're going to be coming up to. But I'm surprised sometimes that people have in their mind that you can describe the function of a device and that will somehow make the device itself unique.
Is that for me, Jane?
Yeah, I mean, do you have thoughts on that? Yeah.
Yeah, and you see this in the software world, whether it's just kind of pure internet-based software or software being performed by a particular device that's not just a general purpose computer, where especially if you're just not skilled at writing software applications, you tend to go to describing it as a function. Just like if you were doing mechanical applications, you call everything a member. Or, you have these generic terms that you're using just because you don't have the vocabulary yet. So you really need to be thinking about, and go back to your inventor if you have to, but to find out this information of how is component A talking to component B, and what is the function going on between these, but how are they also communicating with each other? Or how is this interrelationship between these different modules of this software? How does it work? Having that, even that little bit of background will help. And if we do have younger attorneys on here, I'll encourage you, the older that I've gotten, the more self-confidence I have in ability and being comfortable with what I don't know is what my point there. Because I don't know everything, and I definitely didn't know everything when I first started practicing. And I mention that because if you don't understand the functionality of the invention, in addition to kind of the hardware side, go back to your inventor and have them explain it to you. They love talking about their inventions. I don't care if they're a Fortune 100 company or the solo startup. They love talking about it, and they'll appreciate the questions and you digging down to find those answers.
Yeah. And, and I just, go ahead, Sal.
I was just going to add to that. We see a lot of usage of phrases like based on in software, and this, some tasks, some algorithm is performed based on something else, and there's a situation where that's fine, and there's a situation where you want to make sure you've got the right terminology for that. If that relationship is not really where you're trying to hang your hat on for inventiveness, you're not going to argue that limitation is your hook to get around obviousness, or certainly not for 101, then keeping that relationship broad using kind of based on language is fine, perhaps. But if that's the limitation that you're really going to say, you're going to point to and say, okay, that is distinguished from the art for these reasons, based on isn't going to cut it, and the examiner is going to call you on that. You'll definitely realize it. And so having the right language to describe those relationships for the claim is going to be helpful, but also, it's not just going to be a phrase that you're going to throw into your specification. You're probably going to have, to your next point, a flow chart that describes what exactly is going on when you say X step, right?
Yeah.
So yeah, I would look for those kind of like nonce relationships and figure out, okay, does it need to be at this level of breadth, or can I articulate a tighter relationship?
Yeah, and it's the same. There's in the mechanical world, like adapted to and adapted for. I mean, you read that and it's like, what does that mean? What does it cover? And people seem to think that that's limiting, and it can be limiting depending on the specification. I mean, and it can also be just a term that doesn't carry any meaning whatsoever. So you have to be really careful, and that's why the disclosure matters so much. And it's not just with software; it's everything. I mean, this is really a disclosure revolution. That's what Joe Root, who's written a book on patent claim drafting and patent drafting for it's a Lexis publication. He calls it the disclosure revolution, and he's right. I mean, if it's not in your description, you're out of luck. It has to be there. It cannot be thin. It must be real, and it has to be technical. And then my next bullet point is drawings are your best friend. And this is for every application. I think there are too few drawings filed in probably at least 95% of applications. I mean, they're cheap, they're easy to get, and they disclose so much, and they force you to write and describe more, and people are always asking me for good examples. And some of you probably know that John White and I, we started teaching a patent practice course for beginners. And one of the patents that we use as an example family is the family to the Ring video doorbell. And if you look at those patents that cover the Ring video doorbell, there are dozens of illustrations, drawings in those patents, and of everything from flowcharts to schematics to screenshots to shots showing the video to interfaces to graphs to absolutely everything that they could possibly think about showing in order to describe what is actually going on. And I think you need to do that, right, Jen? I mean, that's what makes these types of inventions real. It turns it into a system, not software.
It really does. And even talking about it outside of the prosecution context, it's also really important for IPRs and for litigation. I know on the litigation side that when we're representing the plaintiff, we love to have those patent drawings because they're easily understandable by a jury. We can see things visually and understand it much better, especially if it's very difficult concepts. And then for the prosecution side, remember what you're dealing with an examiner. They don't have a lot of time to examine your application. They probably have not read every single word of your specification, but I can almost guarantee you they flip through the drawings. And so if you have a lot of drawings showing the invention from the beginning, you put them in a state of, this isn't interesting. Maybe there's something here for patentability purposes.
Yeah. Yeah. And go ahead, Sal.
I was going to say, sometimes we get kind of mired in all the latest cases and everything. Sometimes it really helps to go back to basics. Exactly what I would be teaching my students right now about the use of drawings is, first off, keep in mind that drawings are just embodiments, right? They're reflective of embodiments. They're not the invention, right? And second, one of the first things that we're all kind of taught about how to use drawings is, after you've got your claims in place, or at least, a representative claim set, you put your drawings together and then you can talk through the drawings with your specification. So if you're not doing that, you're making it harder for yourself. You're making it harder to kind of meet your client's budgets too, because by the time you've got your full drawing set in place and you've walked through all of the various embodiments reflected in those drawings, you've got your narrative in place. You can tell a story. You can do kind of that next level sort of, extemporaneous, talking about your invention, in just narrating through those drawings. So you can't discount the value of a well-crafted, not just set of drawings, but an organization for those drawings.
Yeah, I couldn't agree any more whatsoever. Now I'm looking at the clock. We got 15 minutes left. We're probably not going to get to everything I had hoped to get to, but I want to push to the next slide because I want to get at least some on this means plus function stuff. Jen, this was from a slide deck that you had done previously, so I'll let you drive through this one if you'd like.
Sure. So we all know 112F, but I'm sure many of you have recently experienced in the past couple of years more of a focus from the Patent Office on interpreting claims under 112F. And so I have given a 112F functional claiming presentation a few times, and it really focuses on Williamson v. Citrix, which is a 2015 case, so it's been around for a while, but it's the one that is being applied by the Patent Office and interpreted. So a couple of things with 112F, you probably are seeing more rejections. You're probably seeing more interpretations, I should say, of 112F, even in the software, let alone the mechanical and electromechanical world. My biggest thing here is to get away from using nonce terms. And the Patent Office, I think, is broadly interpreting what a nonce term is. So Williamson came in and said a nonce term is essentially some adjective followed by device. And that word device is a nonce term, and it's really just replacing the means. And so you have a situation where you have adjective plus device, so moving device or pivoting mechanism, configured for or adapted to perform some function. The Patent Office is saying, look, you're taking the word means for a function and replacing it with this nonce term. We're going to interpret it under 112F. Try to get away from using those nonce terms. We keep on, I think we've gotten into using them because they've been so prolific in prosecution and how we write applications. But for example, the light capturing element, don't call it a light capturing element. Come up with a more generic term, but that does not include a nonce term. And then my other big thing with respect to the 112F is I think a lot of examiners don't really believe that it's 112F, but they need to put it on the record and they need you to respond back why it's not 112F. In other words, why a skilled person would understand that the moving device as used in the claims and in the specification would be understood by a skilled person to mean a particular device as opposed to this generic concept and word. But push back, I mean, unless you want them interpreted under 112F, but if you don't, and you see that in your office action, you need to be either amending your claims or responding, because otherwise that 112F interpretation is going to follow you all throughout any future litigation or post-grant.
Now, Jen and Sal, I have this question for you guys. Now, what is the harm, if any, in your view, of having several, I mean, I'm not saying like the entirety of the claims, but having a claim set that is means plus function? Does that provide any concerns when you look at the patents? Sal?
If it's software, I might be a little bit concerned about written description and the support for any of the means plus function terms. But apart from that, it's good practice to vary your claims. And we were talking about IPR proofing your patents before. Guess what a petitioner has to do if you come up with means plus function claims? They have to define the terms. And they need to provide their claim construction on the means plus function language right up front. And maybe it's to your advantage, maybe it's not, but it's more work. And if you're not putting all of your eggs in that basket, it's just another tool. So it's one of those things, again, that we've sort of gotten away from because of all the negative implications of means plus function language, how limiting it is, if nothing else. But it's still a tool in your toolbox, and if used appropriately, it gives your patent even more flexibility.
Yeah, and I agree with that. And I would also say, and Jen, I'd like you to get your thoughts on this too. I would also say would not be afraid to use means plus function even in software. Now, I understand about the algorithm cases, and I know what that means about the level of disclosure that you're going to have, but it is a tool. Either way, I look at means plus function language, particularly with software, is it's an extremely heavy garlic. A little bit's going to go a long way. If it's not software, and means plus function languages doesn't create the same level of anxiety, and it protects everything that's in the specification, and you're never going to get the budget to write all the claims that you could write to cover everything you've disclosed in a well-written specification anyway. So I would throw in a few of those claims. And the other thing too, I hear from patent litigators, and this I think surprises patent prosecutors, but the patent litigators I talk to always say, give me means claims. Where are the means plus function claims? I want means plus function claims. And I think it's because of what you just said, Sal. The defendant has to define these terms. It adds uncertainty into the process. And anytime there's uncertainty in the process, that makes it more likely that you're going to have an opportunity to settle. Jen, thoughts on any of what we've been talking about there?
Yeah, I'll agree with both of you. I think Sal's point, he started out saying, in general, he wouldn't necessarily recommend, I want to put words in your mouth, Sal, for software. And the reason is because it exposes the weaknesses if you haven't properly defined your algorithm, because that is the structure.
Right.
So if you've properly defined your algorithm for all the reasons that we've already talked about, then you shouldn't have a problem. So you could kind of also think of it as a test for, have I done it? But
yes,
if you haven't
exactly.
done it, then yeah. I mean, if you haven't done it, then you are shooting yourself in the foot, because it does expose that weakness. But I also like means plus function, and I've actually started doing a few. Maybe for the first time in well over a decade, have I started putting some in.
Good for you. Good for you. Well,
but
the thing is
yeah,
I know that there's academics out there that are saying that they think that with software, the way that these patent specifications should be interpreted is all of them should be interpreted as means plus function, meaning that if all of the algorithms are not disclosed, then the specification is defective regardless of what claim technique you used. Now, that has not caught on yet, but who's to say that that won't catch on? So yeah. I like to say, and we're probably not going to have time to get to the real good conversation on the budget that I wanted to do, so we'll have to do that another day. But I understand client budgets, but if you get a client that's willing to pay you to do what needs to be done, like a well-funded startup that's going to have this as a foundational document, you're going to want to, I think, file the specification so you could use means plus function claims if you wanted to.
I 100% agree. 100% agree. And then kind of a couple of quick 2 points on that is, do consider them for when you get pretty far in your continuation practice. If you're on your third, fourth, fifth continuation, might as well. You need a variety of claim scope anyway. And also consider kind of mixed media claims, you can maybe call it, where not every single element in the claim is a means plus function claim, but maybe one of them is. This is especially helpful in mechanical and electromechanical, where you have good disclosure for perhaps one concept, and you want to just be able to catch everything in a means plus function with that.
Yeah. Now, I think that this is probably the last substantive slide we're going to get to, unfortunately, but this is, I just wanted to, I can drive through this one pretty quickly, but this is what I've heard, and we've written some of this in articles on IP Watchdog from examiners regarding 112 issues. And the one thing that comes up a lot when you talk to examiners is they really want you to check your specifications and claims too, but really They want you to file things that don't have obvious 112 deficiencies. Now, at the bottom here, I think one of the examiners puts their finger on where a lot of these problems come from, and it's with foreign translations. If possible, please check and correct any foreign translations before they get to the examiner. And that's a direct quote. All examiners despise how much time, despise was the examiner's word, despise how much time it takes to sort them through them, when for most of us, time is our most precious resource. So they view 112 rejections as a waste of their time. And if you're filing things that have got a bunch of 112 issues, you're starting off on the wrong foot, and you're wasting the first, you're just throwing the first action away. You're flushing it down the toilet. And that's unfortunate. And let me just push to the last couple slides here before we wrap up. Because LexisNexis is the sponsor of this webinar, and our sponsors make all of this possible to bring to you guys for free. And they have a tool that helps with 112 specifically, and it's called PatentOptimizer. And you can go through it, and it can check your words and make sure that what you're using in the spec is what you're using in the claims, and that you've defined things, and that you're not using any of what we would call patent profanity that's going to get you into trouble, and make sure that everything's got proper basis. And the part of it that I really like here is this: we'll check your drawings and make sure that everything that you've used in the drawings and numbered, labeled in the drawings, is actually discussed in the specification, and check for consistency and accuracy. And these little things matter. They're very important, but they matter. So we're not going to have a lot of time to talk about that, but if you want a test drive, please follow up with Maria Marino, and here's her contact information, and give PatentOptimizer a check. If you're in the market, I really would appreciate it if you would do that. They make these possible for us, and they've been a long time very good sponsor for IP Watchdog. So guys, in the last couple minutes that we have left, what I would want to do is try and put a bow on this for everybody who's here. I'll ask both of you the same question. What do you want people to leave remembering? What is the one or two things that is the most important to weave into their daily practice based on where we are 2018? Jen, I'll start with you, and then Sal, I'll give you the final word. Jen.
Yeah, I think when we're drafting these long specs, we can sometimes get caught up in trying to say things elegantly and with proper word usage and just making a pretty document. And sometimes I tell my team members, step back and say what you really mean. Describe the invention. Look at it. What do you see? Where do you think that cool factor is? Why is this thing advantageous? Remember why things should be able to get patents. And if you step back and look at it that way, I think it really helps to evolve your patent application, as opposed to, again, that regimented, this is the way I'm supposed to do it, and these are the words I'm supposed to use.
Yeah, that's really good advice. Sal, your final thoughts. What do people need to leave remembering so they can weave into their daily lives?
Yeah, I mean, I think people get told way too often what not to do, and they internalize that very easily. I'll just stop doing background sections. I'll stop doing this or that. But you have to remember all the different tools you have in your toolbox. And, when there's a challenge, like Jennifer said, step back, think about the concepts, think about how you're going to convey them, and then look through your entire toolbox, because you have all of these options available to you to tell the story, to convince a juror, convince a judge, convince, somebody who's going to be licensing your patent, whatever the audience may be, that there is truly something innovative here. And you really need to be thinking about it from all those different perspectives and using your full toolbox effectively.
Yeah, I think that's great advice. And excuse me, where I would leave it is my final parting thought would be, and I've said this, many times, is that the person who this document needs to be relevant to is that hypothetical person of ordinary skill in the art. That skilled person is who we're writing this for. And I think a lot of times anymore, we've started writing these applications so that they are a bit dumbed down so that Joe Average can understand them. And the problem is if you really have a unique innovation in 2018, Joe Average might not be able to understand the science, the physics, the software, the biology, chemistry, whatever the case may be. So at some point, Joe Average probably should stop being able to understand the patent, and it should be a technical document, a thick technical disclosure. Now, I'm not saying try and make it so that people can't understand it or it's hard to read, but it has to be true to the invention. And I think sometimes you get reading these things and the judges understand them too much. So they sometimes think, well, if I understand this, it can't really be an invention. And maybe I'm projecting, but I'm a big fan of the thick technical disclosures. Thin just doesn't cut it anymore. And that's coming from the fat guy. So, all right. So hopefully you guys had some fun here today. I really appreciate you joining us. Jen, Sal, thank you so much.
Thank you, Dean.
And thank you, Gail, and thank you, LexisNexis. And we'll hopefully see everybody on a future webinar. Take care.